The United States Supreme Court in April of 2014 came out with a decision in Navarette versus California. This is a case involving an anonymous tip made to 911. The facts of the case are that a female caller made a phone call to 911 dispatch in California. She described to the 911 dispatcher that a silver F-150 pickup truck had just run her off of the road. She also described the highway that she was traveling on, the direction that she and the pickup truck were traveling, and the mile marker where the incident had occurred. 911 dispatch relayed this phone call and this information to the California Highway Patrol, who then proceeded to the area. About 15 minutes later, and about 15 miles down the road from where the caller described the incident from happening, the California Highway Patrol came across a silver F-150 pickup truck, traveling in the same direction described by the caller. The Highway Patrol got behind the pickup truck, observed it for about 5 minutes, and even though they saw no more bad driving and no more suspicious behavior, they pulled the pickup truck over. Once the pickup truck was pulled over, they found a large amount of marijuana in the bed of the truck. The court in this case ruled that this anonymous tip in particular was enough on its own for law enforcement to pull the vehicle over. In the majority of cases handed down by both the North Carolina courts and the United States Supreme Court, an anonymous tip is rarely enough for law enforcement to pull over a vehicle without corroborating that tip first. The court is concerned about the reliability of the tip and the information given in the tip. However, the court ruled in this case that because the caller gave so much information, because the caller was clearly an eyewitness to the behavior, and because the driving was so bad that she described, they could use this tip alone to pull the car over. And the court found that that was significant indicia of reliability, and specifically that being run off the road was the sort of driving behavior that gave a strong indication of impaired driving. The court seemed again to be very concerned about whether anonymous tips are reliable or not, and was quick to caution that anonymous tips are generally still not enough alone for law enforcement to pull a vehicle over. Law enforcement was also able to respond to the area and find the vehicle in an area that was consistent with what the tipster had said. All of these things together were enough for the court in this particular case with these particular facts to find that there was enough for the law enforcement to pull the vehicle over. So, what does this mean for North Carolina law enforcement? This does not change previous cases that have said that anonymous tips alone are rarely enough for a law enforcement officer to have reasonable suspicion to pull a vehicle over. Law enforcement should still corroborate the vast majority of anonymous tips they receive by watching the driving of a motor vehicle or the behavior of a suspect. This sort of corroboration with an anonymous tip is usually what is required for an officer to seize someone based partially on an anonymous tip. This case does give some specific examples or specific facts that may mean that an anonymous tip made to 911 is enough for a law enforcement officer to pull someone over or seize someone that is walking down the street. The court needs a totality of the circumstances that indicate that the tip is reliable. Ways that a tip can be found to be reliable include how much detail the caller gives when they call 911. The fact that the caller is in fact an eyewitness to the behavior, and the fact that the behavior described by the eyewitness clearly indicates that a crime is occurring or has just recently occurred. If all of these things are in place, an anonymous tip made to 911 may be enough alone for law enforcement to stop a vehicle or seize a person. However, the cases that have been ruled upon by the United States Supreme Court and the North Carolina courts requiring corroboration are still good law, and law enforcement in most circumstances should get corroboration for an anonymous tip before they make a seizure.